Hello, everyone, and welcome to another episode of War and Words, the podcast by the Conflict Law Center. Today, we are very, very happy to have with us Dr. Marco Longobardo, who is a reader at Westminster Law School and is widely published in the field of public international law, including in the jus ad bellum, international humanitarian law, and international criminal law. He is joining us today to discuss his book, The Use of Armed Force in Occupied Territory, which was published by Cambridge University Press in 2018 as part of our Israel-Palestine Symposium. Thank you so much for joining us today.
A pleasure. I'm very happy to be here today with you.
So to start off with, and for the benefit of our audience who might not have read the book, could you just briefly explain the key things that you talk about in the book?
Yes, with pleasure. The book addresses under different areas of international law, which is the legal framework that applies to the use of force in occupied territory. The main problems in relation to the analysis of this topic is that there are different sources of international law that are applicable. Sometimes, apparently, they contradict each other. So I wanted, with my book, to try to clarify which is the legal framework, to navigate this maze of different rules. So I have a chapter analyzing whether jus ad bellum, the UN Charter, basically applies to the use of force in occupied territory. I have a chapter on the role of self-determination of people in relation to the right to resistance, and then I have more substantial chapters on the role of international humanitarian law and international human rights law. So more than analyzing each military operation in a certain occupied territory, I try to offer a broader reconstruction of the legal framework that in principle can apply to any use of armed force in any occupied territory.
Yeah, and I thought it was such a great book to read, especially given the current situation. There were so many things that you had answered in the book that are currently just so heavily contested right now. And I wanted to start off by asking if you could explain the right to resist an occupation and how that exists, how that can be exercised and by whom, and whether that right inheres in the Palestinian people.
This is an excellent example to discuss how international law developed in an incoherent way in relation to the use of force in occupied territory, how different legal rules from different branches of international law can clash. In relation to my conclusion, I will start with them, is that international law overall supports resistance against the occupying power, even if the support doesn't amount to conferring a specific right. And I don't think there is a big difference in our discussion whether right is there or not, but I will try to explain my point. First of all, the main normative layer that we should address is jus ad bellum, also known as jus contra bellum. And clearly the state that is occupied has the right to resort to self-defense because occupation is a form of ongoing armed attack. The typical example was Kuwait when it was invaded by Iraq in 1999. But this doesn't apply to the specific military operations within the occupied territory that at that point will be already incorporated in that jus ad bellum evaluation of the entirety of the reaction against the occupation. If we move to the local population in occupied territory, that is the trickiest point, we have a really incoherent subject. First of all, the local population doesn't have the right to self-defense. There was debate at the United Nations, in particular, states from the Global South wanted that self-determination could be actionated even by people without reference to a state, but this wasn't accepted. In fact, it's not self-determination. It's not, self-defense that governs resistance against an occupying power, against an apartheid regime, for instance, in South Africa. And this is something that doesn't mean necessarily that you can't resist against the occupying power. It means that you just don't have to do that in light of Article 51 of the UN Charter, so you don't have to demonstrate there was an armed attack and so on and so forth. This is very clear from the preparatory works of the UN Charter that self-defense is only available to states. Having said so, more complex is the situation under other rules of international law. I think the main rule that supports the resistance against the occupying power is the principle of self-determination of peoples. As maybe our audience know, the principle is enshrined in the UN Charter, but it's never defined. However, over the years of the decolonization, the UN General Assembly has adopted some resolutions that can be used to reconstruct customary international law in this field, as confirmed by the International Court of Justice. In most of these resolutions, I would say all of them support clearly the resistance against occupying powers. However, some authors consider this support doesn't encompass the use of force. I don't think this is correct. Some of these resolutions clarify that armed struggle against the occupying power is legitimate. Even more complex is the situation of IHL. I think here we see the entire clash in this field, because international humanitarian law does not prohibit resistance against the occupying power. And this is a huge achievement in the sense that when IHL was codified more than 100 years ago, before the emergence of the principle of self-determination of peoples, strong states wanted the provision prohibiting resistance in occupied territory because they thought they would have occupied the smaller states in the future. On the contrary, smaller states, I think about Belgium in particular, were very much against the idea of prohibiting resistance. So the only point of agreement that was found is that resistance in occupied territory is not regulated by IHL. IHL, the law occupation in particular, clarifies that the local population doesn't have a duty to obey the occupying power, doesn't have a duty, but at the same time, the IHL recognizes that the occupying power can protect itself against the resistance. And to a certain extent, the further Geneva Convention clarified that resistance in occupied territory, if it fulfills some criteria, is legitimated in the sense that participants have the right to prisoners of war. So which is, just to be brief on this, international law doesn't prohibit the resistance of the local population. There is a sort of legitimacy, in particular in light of the principle of self-determination of people, but at the same time, the occupying power has the instruments through criminal legislation, judiciary, and the use of force to protect its own interest against the resistance. It's an unsatisfactory answer.
Yeah,
it is because international law was codified also thanks to the activity of states who were occupied powers, or who were planning to be occupied powers. I think in general we should remember that international law is a human construct. It's not something inherently good because given by, I don't know, God. It's just a human construct, so we can acknowledge the limits. So this is the situation from the local resistance. What about Palestine? Palestine historically has been recognized as a self-determination unit, what we call the Palestinian territory that comprises West Bank, including East Jerusalem and Gaza Strip. We have so many sources, including the case law of the International Court of Justice, recognizing that the Palestinian people has the right to self-determination. The Palestine Liberation Organization has been recognized as the representative of the Palestinian people. So we can conclude that the acts of use and force performed by Palestinians, in particular under the umbrella of the Palestine Liberation Organization, if they are aimed at ending the occupation, are in principle legitimate. But under international law, not only we have to interrogate the legality of the beginning of the use of force, but also the way in which force is used. So in relation to the 7th October attack by Hamas, there was lots of discussion, in particular in colleagues from the global south or critical theorists about whether the act of Hamas was an act of resistance. The answer is no, because the attacks of Hamas wasn't linked to end the occupation, but was linked to spread terror among Israeli civilians, was caused the indiscriminate attack against civilians. We know the taking of hostages that is prohibited by international law, killing of civilians, and so on and so forth. So it's not only a matter of whether the Palestinians have a right to resist, it's a matter of what they do with this right.
Okay, that's very, very interesting. And I think the reason why a lot of people in the global south and critical theorists are so unsatisfied with international law is because we wish that there were different answers to these questions, but I am essentially a positivist and look at what international law is and not only what it should be.
It is interesting, the point, in the sense that I agree. And here we can see how differently different branches of international law evolve differently. Because the law of occupation HL was codified more than 100 years ago, basically in Europe, in conferences between European states. And that's quite old-fashioned body of law. It's quite conservative. On the contrary, the principle of self-determination of people through the activity of the UN General Assembly was largely the product of states of new independence after the colonization, so clearly with a totally different attitude. I would like just to add that it's interesting that some regional conventions on human rights, especially in the Arabic world and the African Charter of Human and People's Rights, recognize the right to resist the occupation as a human right of individuals. But the opposite is not true. If we look at global instruments like the UN covenants on human rights, they never mention the right of occupation. So we always have to remember that international law is the product of these different attitudes. And my question is, what does it change having a right or not? I think at the moment, very little.
Okay. I did think it was really interesting the way you talk about the right to resist or the right to self-defense, and you look at it in tandem with Article 43 of the Hague Regulations, and the fact that that wouldn't be there if there was the right to resist. What struck me about reading this in the current context was where you talk about the legitimization given to resistance to occupied territory in terms of Article 482. And I couldn't help but being like, okay, that definition, organized resistance movement in an occupied territory, does that only not apply to Hamas because it doesn't belong to a party?
I will try to unpack your question. My idea in relation to the use and force by the occupying power is that this is not governed by jus ad bellum. We can discuss this why I agree in this with the International Court of Justice. My idea is that in occupied territory, the law occupation governs when use and force is possible. This is something weird because usually HL only governs the way in which force can be used. But we have to remember that the Hague regulations were codified before the UN Charter. And Article 43 of the Hague regulations gives the occupying power the responsibility of restore and ensure public order and civil life. So I could build upon this to say that force should be primarily used to restore and ensure public order. We could think that Article 43 is old-fashioned. Article 43 doesn't mention the security of the occupying power, but if we look at post-World War II case law, it's clear that the occupying power could protect itself. But let's assume that Article 43 of the regulations is old-fashioned. The problem is that the security of the occupying power is explicitly mentioned by the Fourth Geneva Convention. Article 64, paragraph 2 says that the occupying power can alter the law in force in occupied territory in A, B, C. There are certain cases, including to protect its own security. So it's not something just 110 years old. It's something that was confirmed after the entry in force of the UN Charter, just to be clear. Then the question on the status of prisoner of war is interesting, but I think it's also misleading, in the sense there is a huge perception among scholars that occupation and hostilities are two binary situations. If there is hostility, there is no occupation, because occupation is defined as exercise of authority, actual authority over the hostile territory. So it is very often said that occupation means control. If you have the control of the territory, there are no hostilities in the territory. This is, for instance, the position of one of the most prominent international humanitarian law scholars, Professor Sassoli. However, I tried to find in international humanitarian law some references to hostilities within occupied territory. They are not many. Usually there are references to military operations, so we can discuss whether military operations and hostilities are the same. But for sure, there is a reference to resistance in occupied territory in the criteria for the prisoners of war status. This means that the drafters of the Fourth Geneva Convention believed that you could have a resistance in occupied territory, so hostilities in occupied territory, without having without this putting the occupation to an end. Having said so, does Hamas fit that definition of Article 4? I don't think so. I don't think so, because it's clear that the definition of legitimate combatant should recomprise between the Article 4 of the Fourth Geneva Convention and Additional Protocol 1, conducting actions in line with international humanitarian law. And this, for sure, it's something that Hamas hasn't. And in any case, again, which would be the difference? The difference would be that Hamas combatants, if captured, would be entitled to the status of prisoners of war rather than being subject to punishment under domestic law of the occupied power. Just this is the main difference. At the moment, from what I understand, there is not much emphasis on capturing the enemy. But it's clear that there is more emphasis on killing them, destroying them. But irrespective of this, I don't think that all the cumulative criteria of Article 4 and Additional Protocol 1 are respected, in particular in relation to conducting operations in line with IHL. The other question that you put, and it's very sophisticated, is whether in any case Hamas belongs to a party of the conflict. And so the question will be, which is the party of the conflict? According to Israel, the conflict is between Israel and Hamas. But if this was the situation, sorry, I lost, sorry.
No, it's okay.
Second, I forgot that. Okay. In my office, the light goes up. But if this was the situation, I was saying if the conflict is between Israel and Hamas with no link to the occupation, I don't think that it would be tenable to consider it an international conflict. In any way, in 2014, Hamas concluded an agreement with Fatah, that is the main party in the Palestinian Authority, and Hamas, in any case, has always maintained the links with the Palestine Liberation Organization, that is the international voice of Palestine. So I don't think that it is absolute to say that Hamas belongs to Palestine until, at least until Abu Mazen doesn't clarify that the Palestine Authority has no control over Hamas. I think it doesn't, but I don't think this is the position of the Palestinian Authority. Okay. So it's very complex, the scenario. It's the consequence of the fragmentation of Palestinian leadership that is also the consequence of the physical separation between different areas of the Palestinian territory.
Mm. And it's so interesting. I learned about that agreement between Hamas and Fatah from your book. So that was really interesting for me to learn. I wonder whether my counter to that might be that it does, for me, it does hinge on the belonging aspect. But also, I think it puts the Palestinians in a difficult position. I mean, I'm not arguing for Hamas to get POW status. I don't, in terms of resistance movements, I agree with you in the sense that could it be a legitimate resistance movement? I think the first phase of when they targeted the IDF, yes, but when they started targeting civilians, no. But in terms of abiding by those cumulative conditions, and one of them being the laws of war, does that come down to it being individually met or met as a group? Because then you have Article 5, which means that if you haven't met that, you face a tribunal. So if you're never going to get POW status because as a group you don't, then what would the point be of having individual tribunals? But I think that's why this conflict is so interesting, because all of these legal issues are teased out of it.
Yeah, I believe that the status of individuals concerned, including for the purposes of the status of prisoners of war, is always individual as such.
Right.
At the same time, the status should be assessed when the individual is captured, and so. And this is it's logical because it's a status protecting the people who are detained. It's not relevant for the law targeting, that whether the Hamas fighters comply with the definition of combatants or not. If they are not complying with the requirements for prisoners of war, they will be in any case fighters. They will be civilians taking part in the hostilities, and they could be targeted as such. Then this demonstrates another of the limits of IHL, because it's quite states are quite uncomfortable to consider members of Hamas as civilians where they don't perform attacks, and this is understandable. Just because it will be, there is a sort of concern of giving more protection to groups or to individuals who fight not following the rules, rather than those who follow the rules, because those who follow the rules can be always killed. They are combatants, they can always kill if they follow the rules of HL, they have the emblem, they carry arms openly, blah, blah, blah. Whereas those who do not do this, they will be civilians unless they are taking active part in the state. So you may know, the ICRC came up with this idea of combat, continuous combat function for this kind of phenomenon. But honestly, this would be primarily relevant if they fulfill the status of prisoners of war or not, if they are captured. From my perspective, it's important that there is this provision in the law occupation, because it recognizes that at certain conditions, okay, but at certain conditions, the resistance is legitimate. We have to pay attention in this discourse, because again, the UN General Assembly recognized the PLO as the legitimate representative of the Palestinians. And even if Hamas is a component of the PLO with the signature of the Declaration of Principles renounced the armed struggle against Israel.
Yeah.
The question is, does this mean that any armed struggle against Israel doesn't have the permission by the PLO? If this is the conclusion, there is no way to even enter any discussion of the legitimacy of the resistance by Hamas.
Yeah.
On the contrary, if the PLO backs this, we could say, in principle, Hamas, as any other Palestinian group, can act in resistance, but in practice, these acts of resistance are illegal, they are criminal because of how they perform. But I don't think the PLO is actively backing them. There is a huge problem, as I'm sure you are aware. It's not a legal problem of the legitimacy of the Palestinian Authority, of the fact that
Yeah.
there is a very old leadership with extremely little legitimacy through elections. There were elections 2006 and they were not repeated. And this is a political problem that creates creates more doubts in the legal landscape.
Yeah, and it's a terrible situation for the Palestinians to be in, that the PA is so corrupt and viewed as just a contractor of the Israeli state in order to conduct a burden-free occupation. Yeah.
It's a huge problem, but it's the voice of Palestine internationally, and it's the Palestine through the PLO that is now called the State of Palestine at UN. It's through the PLO that Palestine is suing the US before the International Court of Justice for the relocation of the embassy. Case is pending, even if it's quite dormant. It's through the PLO, it's called the State of Palestine, that Palestine ratified the statute of the International Criminal Court and giving the International Criminal Court the possibility to have jurisdiction of the facts. So, the problem with these situations, the tragedy is that if you follow a certain legal reasoning, like the PLO is the representative of Palestinian people, then you have to conclude that Palestinians who fight without the support of the PLO are not fighting a legitimate act of resistance. I don't have a personal position. I don't think it's a problem of personal position. I think it's a problem of the limits of international law that always looks at a sort of organization to represent the people. Usually it's the state, the government of the state. Other times it's a movement of national liberation like the PLO or Palestine. If today Palestine became a state, that is a question, as you know. But something totally rogue, like Hamas, who doesn't listen to the PLO, doesn't listen to Abu Mazen, it's very difficult that could receive any amount of legitimacy in international law. Irrespective of the fact that how Hamas behaves, I think that the recent acts are just last episodes of a long series of criminal acts. But irrespective of this, Hamas is considered rogue within the Palestinian leadership because they do not follow the Palestinian leadership.
Right.
At the moment, the only voice internationally recognized for Palestinians is in Ramallah, is not in Gaza. Having said so, how this helps local population, I don't know. The problem is that the local population are only caught in this web of interest, of rules that probably leave them with a little protection, I understand.
Yeah, and it's interesting to look at it from a historical perspective as well, because it seems that international law only really recognizes resistance movements once they win and become a state. So Bangladesh was very easily accepted because Pakistan had infringed upon their right to self-determination when they emerged on the field. And similarly with the FLN's tactics, once you win and overthrow your colonial power, you're treated differently historically, but as well as legally. And perhaps the only resistance movement I can think of is the Polisario Front, which received a degree of recognition. But yeah, it does depend on that.
I think this is an interesting consideration. For some reasons, I think it's correct. For others, I think it's not. In the sense that all the international law textbooks, I think correctly, consider that secessions outside occupied territory, secessions, are not permitted, neither prohibited by international law. They are neutral, they are facts. If the secession consolidates, in fact, like it happened probably with Kosovo, we could say, the new entity is a state. If the secession does not consolidate, in fact, like Catalonia, we tried to have the referendum around 10 years ago, 6-7 years ago, I don't remember, in Spain, then there is no problem of asking if it was legal or not. It is just something that doesn't exist anymore. However, this is the rule for secession. International law moved towards recognizing legitimacy to free armed struggles that can lead to secession or can lead just to fight for self-determination. These three situations are fight against colonialism, fight against occupation, and fight against apartheid. So the General Assembly conferred legitimacy to certain movements fighting against colonialism, to certain movements fighting against apartheid, like the ANC, to certain movements fighting against occupation, like PLO, but like the Fronte Polisario, like the SWAPO in Namibia. So I think the position is more supported. Whereas if tomorrow I'm Sicilian, if tomorrow I organize a rebellion of Sicily to leave Italy, I will not have from the beginning any legitimacy. Maybe if I manage to defeat the Italian troops and create an independent state, maybe at the end that will be a state. But that's a mere fact for international law. The different is the possibility to have an international voice for a people under occupation, under colonialism, and apartheid. In fact, Palestine has always had a voice, before as PLO, then as state of Palestine at the UN, the General Assembly in particular, like for Fronte Polisario, like SWAPO, like the ANC, they were recognized as movements.
Right, yeah, and so what do you think about in terms of looking at it, and I'll ask you in a little bit about the classification of the conflict, because I think that's also very contested in this current situation. But in terms of Israel's right to self-defense in a land that it occupies, do you think that jus ad bellum notion applies here as well?
I think that there is lots of confusion these days on this topic, in the sense that there are certain voices who claim that jus ad bellum, in particular the right to self-defense under Article 51 of the UN Charter, does not apply. I agree. Now I will explain why I agree. But this doesn't mean that Israel is left without possibility to protect its own citizens in occupied territory, especially outside, as it happened with the 7th of October attack that was in Israeli territory. As I said, the IHL provides for the possibility of the occupying power to protect itself. But why I think it's a very peculiar debate, because Western states are very, very consistent in saying that Israel can invoke Article 51 of the UN Charter in self-defense. Whereas Israel confirmed as official legal position for this escalation that Article 51 doesn't apply.
Okay.
Israel does not apply Article 51. The legal justification of Israel is that Israel is involved in an ongoing conflict with Hamas. Jus ad bellum only applies at the beginning of an armed conflict, so there is no need to invoke jus ad bellum for this new escalation. Now, this is something Israel is quite consistent in relation to, for instance, the attacks against Hezbollah bases in Lebanon, against Syrian objectives. I think this is, in general, a wrong justification, but is a justification that applies to the specific circumstances of occupied territories. So Israel considers that Article 51 does not apply, but considers that Gaza is no longer under occupation. I believe that the Gaza Strip is still under occupation, and because of this, Article 51 does not apply. But irrespective of this disagreement of the characterization of Gaza Strip that we can discuss, it's interesting that the Western states are so focused on Article 51 for Israel, whereas Israel doesn't invoke it. In the past, for other previous escalations, Israel has always said that the primary basis is the ongoing armed conflict with Hamas, and in any case, there is also Article 51. So giving the idea that Article 51 is less important. In relation to the recent escalation, I've seen a document translated in English, so I don't take responsibility for the how accurate was the document, saying that Article 51 doesn't take any role. To be more precise, that it's not necessary for Israel to invoke Article 51 because there is an ongoing armed conflict with Hamas.
Okay.
Which is my legal position. My legal position is that occupying power can protect their own citizens under the law occupation. However, I don't think that jus ad bellum is applicable to justify any military operations within occupied territory. Because, as we said, jus ad bellum governs the entirety of the beginning, of the use of force between states. So any other episode of use of force within the occupied territory should be calculated in light of for the assessment, of the original use ad bellum. So in the case of Israel, everything that is going on these days should be calculated in light of the original claim of Israel of self-defense at the beginning of the Six-Day War. But it's not relevant it doesn't apply to justify the specific military operations. As very well known, this is a theory that puts together very different sources, including the International Court of Justice, that in the Wall opinion clarified that Israel cannot claim Article 51 because it never claimed that armed attacks were originating from a state, and because the armed attacks were originating from occupied territory. That I think is this second prong the most relevant here. But states have different views. Western states keep invoking Article 51. That, again, in my opinion, it's not relevant for the individual missions. I think that Israel has the right to use armed force under different sources. What I would like to clarify is that I try to analyze the law as it is. I find peculiar that these days, most people who try to deny the applicability of the right to self-defense to Israel want to do so to support the Palestinian cause.
Yeah.
It's not always the case, because saying that Israel does not have a right to self-defense under Article 51 because it doesn't apply to occupied territory means that Israel doesn't have to rely on the occurrence of an armed attack to use that force, and Israel doesn't have to react according to the criteria of necessity and proportionality in the reaction, because just that body of law doesn't apply. When I wrote the book, I followed this reasoning because I believe that the limits of this right to use force are in the law occupation, in the system created by Article 43 of the Hague Regulations and Article 64, paragraph 2 of the Geneva Convention. But it's far more difficult to build a legal constraint to the use of force on IHL rather than use ad bellum. So I think this is the reason why we have a very different perspectives, both on the Israeli side and the Palestinian side, reaching the same conclusion, the inapplicability of use ad bellum. They like this for different reasons. I think it's just how international law developed. I think it's the right answer, legally speaking. But it's important to remember that it's a view that it's open to abuse.
Yeah, okay. So that's interesting because you're saying that it's, are you saying that the jus ad bellum is more limiting or less limiting than Article 43 plus Article 64 too?
It's a difficult question. I think that jus ad bellum in self-defense is, even with all the debate, the boundaries of jus ad bellum are more clear than the boundaries of the law occupation as an instrument to constrain the use of force by the occupying power. That was the aim of my book. Okay. I wanted to demonstrate this, but it's more difficult and less accepted generally. On the other hand, and this is a question for scholars, and it doesn't pertain only to Palestine and Israel. My book and my expertise is in general under occupation. I don't claim any regional expertise. Is whether in this point, we should apply the law that we think does apply as a matter of international law, or we should select the most convenient legal framework for our interest, the interest that can differ in relation to different in occupied territories. So I tried to reconstruct a system that I think it can work. I think it's the system that better fit how the occupation developed, how it relates to other branches of international law. But if somebody tells me that this system has certain limits, I'm open to acknowledge them, because again, international law is a tool of powerful states, was created as such, and it's not something inherently good. I think the world is better with international law than without, but we can acknowledge at a certain point that in this thing, international law has certain shortcomings. It's a human.
Yeah, and it's been interesting seeing the blogosphere recently talking about all of these issues. And I think it was interesting reading Ralph Weil talk about how Israel doesn't have the right to self-defense. And does that give it no recourse against non-state actors? Yes, which is unfortunate, but it happens because these circumstances are of Israel's own making. And Mark Milanovic also had an interesting point, which is that this is my reading of one of the things that he said in his piece, which was that Israel would have the right to self-defense if this is my interpretation, maybe he doesn't say this, if the Palestinian resistance was so strong that in the end it was Israel that had the right to self-defense. Does that make sense? For me to understand that way?
I am quite, I can say, uncomfortable in discussing the work of colleagues.
Okay, fair enough.
I know personally both Marco and Ralph.
Okay.
Sorry. I liked certain aspects of the post.
Yeah.
Agreed on others, but I don't think it is very elegant to in this way. If you want to know what I think about this
not on the record
topic, apart from the fact that it is in the book that was published before the recent escalation, but then there is in a blog called Armed Groups in International Law, there is my first, I don't know if you've seen it, there's a very brief assessment of the most recent escalation, where I also discussed these points in the terms that we have discussed so far. But I don't feel very comfortable in saying that the previous colleague was wrong, and I prefer just to avoid.
Okay, good. No, I get that entirely. So moving on to the classification of the conflict, I did want to ask, because when I'm looking at the conflict in terms of classification, and when we were talking about it within our style, we were looking at it as an occupation plus an IAC. So the law of occupation applies between Israel and the occupied peoples, and the law of NIAC applies between Hamas and Israel. So you argue that the law of IAC applies. How is that in terms of looking at it from the different paradigms that you do, the conduct of hostilities paradigm applying to Hamas, but then the law of occupation and the law enforcement paradigm applying the rest everywhere else? How is that? What is the difference between those two?
I think that you applied the IAC parody, because you asked me about the prisoners of war status that only exist in IAC.
Yeah.
So you were naturally led.
In kind, yeah.
Now, I think this is the right, as you said, the classification. I would just try to explain this clearly. Conflict classification is based under international law according to the prevailing view on the status of the belligerents. International conflicts are any use of force between states and states only. Non-international conflict are acts of violence that reach a certain threshold between an armed group and a state, or between two and more others. So the status of the belligerents, rather than geographical considerations, govern classification. This is the mainstream view. I don't like it, but I don't go in my book against the mainstream view. I don't like it simply because this is not what the Geneva Conventions consider at the time, but in any case, the practice of it. What I disregard, what I disagree with, is the idea that this classification, this way to classify armed conflict, is unaffected by the situation of occupation. So a situation of occupation can only be created and established when there is an international conflict. In fact, the law occupation is part of the law on international conflict. I don't think that makes any legal sense to apply in occupied territory in relation to the same individuals, the law on Ajax and the law on Ajax, depending on what those individuals do. We're talking about the same individuals. We're not talking about two parallel conflicts with separate entities on the same territories, but literally to the same individuals. And this is not honestly minority views. Maybe, to these days, some people are more vocal than in the past, including some colleagues you just mentioned, in favor of the NIAC classification. I don't think at all this is the minority views. It's a view supported by many colleagues, in particular Daphne Wakande wrote very good things about this. And is a view linked to the fact that the law occupation absorbs and replaces the normal rules on conflict classification. So you can agree with this conclusion, irrespective of which are your idea on how conflicts are classified normally. And again, by the way, it is the view of Israel that applies Ajax rules. There is a very clear case law of the Supreme Court of Israel. It's the same view of the Palestinians. And so, which is the sense to deny the law applicable chosen by the belligerents. Also, thinking about the fact that the law on international conflicts is more developed than the law on non-international conflicts. More protective. There was a clear trend towards unification and the CASMA international law. This is what the case law of the ICTY and the practice of this ICRC are trying to tell us, but still there are differences. And in my opinion, nobody considers at international level, non-international actor considers that is a non-international conflict. This is also because there is this clear idea that Palestine is something different from Israel. And more in general, more correctly, there is under the law occupation the duty to maintain separate the legal identity of the occupied territory, the local population, from the legal identity of the occupying power to avoid annexation. So I think that conflict classification should contribute to this, and in the practice, they are treated as Ajax. Just to be complete, our audience could be aware of the fact that in the first additional protocol, there is a provision saying that wars on national liberation, that is, wars against occupying power, colonial domination, and apartheid, should be considered Ajax. Now, I don't think this is the changing factor in my analysis, because I think they are Ajax because they occur in occupied territory and are in the relationship between the occupying power and the local population. But in any case, there was an attempt in 1977 with the first protocol ban to fill this gap. At the time, there was more confusion, wasn't some there was doubts on whether the occupation applied to Palestine, Namibia, and Western Sahara, because they were not traditional states at the moment of the occupation. So clearly that provision was created to fill that gap. But I totally agree with those colleagues who already at the time said this is totally irrelevant for occupations. It's good for other wars of national elections, but already conflicts with the local population or groups organized by the local population are addicts. So if I have to conclude just for, this applies for me clearly in every occupied territory. If I have to conclude just for the audience to be complete, can we have NIACs, non-international conflicts in occupied territory? Yes, in two scenarios. One I mentioned in my book, only one, that is local population is divided into two or more armed groups having armed confrontations among them. It's probably something that happened in Palestine at a certain point. The relationship between Hamas and Fatah was particularly tense. There were lots of acts of violence, and probably they reached the level of a non-international conflict. And then there is a second case that I didn't think about in the book. It came to my mind after. For the second edition, I will include it. That is whether some nationals of the occupying power take arms against the occupying power. Imagine if tomorrow, unfortunately it's unrealistic, Israel orders all the settlers in West Bank to withdraw into Israel territory. Imagine that the settlers try to resist this by taking arms against Israel. That would be a non-international conflict because it's between a state, its own citizens. That occurs in occupied territory, but there is no link to the duty to maintain a distinction between the occupying power and the local population of occupied territory.
Okay. So you're saying that what was given in Common Article 2 about occupation being an IAC, Article 1.4 didn't do anything to change that?
No, I think it wasn't needed. It was already an IAC.
Okay, so in terms of applying the conduct of hostilities paradigm, so when Hamas acts, they're civilians DPIHing?
Say it again, sorry, you froze.
Oh, okay. When Hamas fights Israel in occupied Palestine, they are just civilians DPIHing?
And this will go back to the question. I think that the IHL is not updated to take into account these armed groups like Hamas or like other armed groups who fight in an IAC, but at the same time they don't fulfill the conditions for legitimate combatants. If you think about this, the additional protocol 1 tried to enlarge the definition of combatants exactly for the so-called guerrilla fighters, to try to recomprise them. So I think that the answer is that probably they do not amount as combatants, so they should be considered civilians. But on the other hand, I think that CASMA international law moved towards considering this participation in more broader terms, for instance, through the idea of a continuous combat function. I think just that is an area in which IHL lags behind. And it's interesting, if we talk about resistance in occupied territory, that there's been certain calls in the US to ratify additional Protocol 1 in last spring or last summer, to better support the resistance against the Russian occupation in Ukraine. Because as you may know, one of the main reasons why the US are not party to Additional Protocol 1 is exactly the definition of combatants. But to better support resistance against the occupation in Ukraine, it was suggested that the US should ratify the Additional Protocol 1. Now, I don't think anybody will go back to that proposal since 7th of October, but it's interesting to understand. it gives us an idea of how in this IHL lags behind, and for sure the Geneva Conventions lag behind. Bishop Erdogan tried to better clarify the situation.
Okay, yeah. That's very interesting about Article 1.4 and Common Article 2, because I hadn't looked at it that way. But I still fail to see the difference between occupation plus NIAC and the conduct of hostilities and other framework. Because if we're saying CCF is now customary IHL, then essentially NIAC law applies.
Sorry, I think I missed your acronym. If we are saying that, continuous combat function.
Yeah.
Okay. I don't know, because we are talking in this moment about a mass that violates the law of war in IHL, and so cannot fulfill the criteria for prisoners of war. But there could be certain situations in occupied territory. Also, sorry, again,
That's okay.
University has to save money for life. So I was saying there could be certain situations in occupied territory in which organized armed groups do not belong to the state, but they fulfill the criteria for prisoners of war. If we consider that NIAC applies, they will never be prisoners of war. Again, think about Ukrainian groups.
Okay, I get what you mean.
So I think that we should, in my approach is maybe it's not the one for which you invited me, but my approach is to try to find a legal solution that applies in occupied territory, irrespective of which occupied territory we are talking about. Then the specificities of a certain situation can prevent us from applying the law. But I think IAC and NIAC law are not the same. And there is a second level that we should take into account, that is the consequences as a matter of international criminal law. Because the statute of the International Criminal Court maintains a strict separation between IACs and NIACs crimes in sense of war crimes. Then, since we talk about international criminal law, it is interesting, I think, it is so necessary, I think, to be as specific as possible when we have, for instance, indictments. And so it's important to classify the correct legal framework as a NIAC or a NIAC. So far, we have very little about this, because as conduct of hostilities, the prosecutor of the ACC has not yet said any word about occupied territory. What I find interesting is that in the boarding of the Mavi Marmara, the boat trying to force the maritime blockade of the Gaza Strip, when the prosecutor dismissed, the old prosecutor dismissed an investigation for lack of sufficient gravity. The prosecutor said that as preliminary examination to understand whether there were reasonable basis to believe that war crimes had been committed, she would have applied war crimes pertaining to Ajax to the hostilities occurred on board of the vessel. And she said this because it's a situational occupation. So I think there is, I might be wrong, but probably the new prosecutor who has an active investigation on the current escalation, I expect to use the same approach, honestly.
Okay, interesting. And I was really interested to read the section about how human rights law applies in tandem with IHL. And I was wondering what you made of the recent Israeli Supreme Court Yeshtin decision of 2019, because I think that came out after your book regarding riots in occupied territory. And especially, I think it was Chief Justice Hyatt who argued that those directly participating in hostilities should be governed by the conduct of hostilities paradigm, and other participants in the demonstration, as well as rioters and instigators, should be dealt with under the law enforcement paradigm. This involves a simultaneous application of two regimes of law to the same event, but to different people. How is this realistic in an occupation?
I don't think it is realistic. Just to be very clear, what I think we have to make a distinction. One issue is whether a belligerent is bound by its own human rights obligations in the conduct of hostilities. Irrespective of whether they are hostilities in occupied territory or not, there is a case law saying that IHL and international human rights law applies together. Our audience might be aware of the fact that in 2021, the European Court of Human Rights adopted a terrible decision. And I say terrible because I wrote an article with a co-author to try to demonstrate how bad was the decision, saying that in the phases of active hostilities between Russia and Georgia that led to the occupation of certain areas of Georgia, the European Convention on Human Rights didn't apply because of the chaos of hostilities. But anyway, irrespective of this isolated contrary voice, there is a certain debate, let's say, on the applicability of international human rights law to hostilities. Mm-hmm. And in any case, all the recent authorities, including that terrible case by the European Court, agree that if there is an occupation, the occupying power is bound by its own IHL obligations, international human rights law obligations that apply extraterritorially. That's one part of the question. Well, there is a second question, that is, when the occupying power uses armed force in occupied territory, which is the model of the use of armed force that should be applied? Because we have two models of the use of force, you alluded to them. One is law enforcement, that is traditionally governed by human rights law, but domestic human rights law, that should be informed by, clearly, international rights law. And then a different set of rules is the one governing the conduct of hostilities, that is IHL, basically, plus, if any, international human rights law. The choice of the model in peacetime is determined by the level of violence that occurred in a specific situation. In the sense that if the armed confrontation reaches the threshold of a non-international conflict as defined by Common Article 3, the state can legitimately switch from law enforcement to conduct hostilities in a NIAC. That is what this is the definition of NIAC. But we need this threshold to be crossed to allow the state to switch from one to the other. Now the question is which is the law in occupied territory? My idea is that the law occupation explicitly demand that the occupying power uses law enforcement. This is the content of Article 43 of the regulations that says that the occupying power must restore and ensure public order and civil life as far as possible, while maintaining the except if absolutely prevented, the law in force of the occupied. Then we have Article 54, if I remember correctly, the table with the numbers of the Fourth Geneva Convention that says that the occupying power must maintain in function public officials and judges. Then we have Article 64, paragraph 2, that says that the occupying power, except in specific cases, should maintain in force the criminal law of the occupied territory. So which is the entire idea of the law occupation? The entire idea of the law occupation is that the occupying power must take the role of the ousted sovereign and must use the same means available to the ousted sovereign to restore and ensure public order. When the ousted sovereign could have, which ways the ousted sovereign should have used armed force? Law enforcement. However, let's remember that Article 43 is limited by the clause as far as possible and except if absolutely prevented. Yeah. So my idea is if the armed violence in the occupied territory reaches the level of a non-international conflict, the occupying power can use some force following the conduct of hostilities. But again, my construction, that is my construction, and I know it's very difficult to follow sometimes, it's based on the fact that I believe the occupation creates a legal fiction, forcing the ousted sovereign to act in occupied territory, forcing the occupying power to act in the occupied territory as if it was the ousted sovereign. So, coming to your question, which is the legal regime applicable in any instance, in any incident? It depends on the level of violence. If the level of violence is below the threshold of a non-international conflict, the paradigm that should be used is entirely law enforcement. That is, the occupying power should use armed force following human rights law and domestic law.
Mm-hmm.
If that level of violence reaches the threshold of a non-international conflict, the paradigm moves back to the conduct of hostilities, and so the occupying power should use armed forces in compliance with IHL plus, if applicable, human rights. I don't think that the same situation can have both features. I don't think so. So it is important to define as strictly as possible the specific situation in which a specific person is targeted. What I think again is that we cannot apply the normal rules of use and force in armed conflict to occupied territory, because in the occupied territory there is a peculiarity. The occupying power is burdened with an administration that should not result in annexation, but at the same time should try to maintain a peaceful governance of the occupied territory. So even if I'm an enemy combatant with a uniform in occupied territory, if I'm not taking part at hostilities in a way that reaches the threshold of a NIAC, I think the law enforcement paradigm should apply.
Okay.
The combatant shouldn't be killed; should be captured under domestic law, human rights law, because again, is the law occupation that forces the occupying power to act in the shoes of the host sovereign. But using it, I understand the limits of my construction. For me, this is quite a narrow path for the occupying power. So I say we don't need the use of bellum and Article 51 justification because we have this construction that applies. On the other hand, I understand that my argument, that I think is quite good on the paper, can be manipulated by an occupying power that say, no, security reasons, no, terrorism. I do whatever I want, whenever I want. This is exactly what I tried in the book to avoid. I try to reconstruct a legal framework that can constrain violence in occupied territory. But I understand that it's subject to cherry picking.
Yeah. And just final question, because I know I've asked so many extra questions that we've gone so over time, but in terms of the amount of questions left over in this area of the law of occupation and how it applies generally, how relevant do you think that the ICJ's upcoming advisory opinion will be on the occupation? And what questions are you most interested in seeing answered by the court?
That's a very interesting point. I think that first of all, we should remember that the forthcoming advisory opinion is on the legality of the occupation in its entirety. So if I don't know which is the outcome, but if the court finds that the occupation is illegal, the court could order Israel to withdraw from occupied territory. Think about what the court did in the Chagos opinion that was about colonialism rather than occupation. But the court ordered the UK to leave the Chagos as soon as possible. And in fact, there are certain negotiations in place at the moment to this end. So if that's the case, if the occupation ends, all these problems are totally irrelevant for the occupation because it will not apply to a territory that is no longer occupied. Unfortunately, I don't think that whichever is the position of the court, the occupation will end soon. Unfortunately, I think that ending the occupation will be a good way to guarantee freedom of Palestinians and to guarantee the safety of people in Israel. But that's my point. What I hope that the court will clarify is the overall legality of the occupation under the principles of jus ad bellum, self-defense, and under principles of determination of people. Because Israel claims that the occupation of Palestine started in 1967 in an act of self-defense, and that maintaining the occupation is necessary and proportionate to that original act of self-defense. And here in this calculation, all the military operations, including the last one, should be assessed. Now, I would like to know by the ICJ if this is the case. Is this occupation still necessary and proportionate in light of the alleged armed attack suffered in 1967? Or maybe the court could also tell us whether there was an armed attack. Second point, the court should see if under current international law, with the huge emphasis on the principle of self-determination of peoples, any occupation is ever justified under the principle of self-determination. And last year, in an obiter dictum, the African Court on Humans and People Rights said in relation to Western Sahara that any occupation, irrespective of any consideration, is today illegal because it's a violation of the principles of self-determination.
Oh, okay.
If the ICJ reaches such a conclusion, that would be probably a turning point in general, because there would be no possible justification of any occupation around the world, even in self-defense, even with the authorization of the UN Security Council. So I'm very curious to read the opinion of the court on this. I honestly don't have any idea on how the court will decide the case. I think there is at the moment a huge pressure because of the recent escalation of the court. But we will see. We can meet again to discuss the
definitely
advisory opinion.
So I know we've been talking for over an hour now, so thank you so much for joining us today.
It was a pleasure. Thank you very much for reading my book and for giving me the opportunity to discuss.
And thank you to everyone who's watched us at home.